I'd first like to take a moment and welcome you and thank you for joining our Business Builder Speaker Series. We meet the third Wednesday every month from 1 to 2 o'clock, and we go over some tips and tricks from industry experts to help you grow your real estate business. Our Business Builder Speaker Series was an idea that came out of the COVID days in 2020, when we couldn't get together in person. We said, let's get together virtually, and we'll bring a speaker on a topic that we think is important and valuable to you. We encourage you to stay connected with us. You'll have a list of all of the socials, where we are, and be sure to tag us and follow us. We also record each of our Business Builder Speaker series. We save them to our YouTube channel and link to them on our website. So you're always available to share them with other people that could benefit, or to go back and rewatch any episodes you might have missed. Here's a list of topics that we've had year to date, and you'll find all of them on our website under the Resources tab. There's one for the Business Builder Speaker Series, and you can go back and catch up on anything that you've missed. And mark your calendar. The third Wednesday next month will be September 18th at 1 p.m. Our next month's speaker is Christina Bell on home staging. She's with No Vacancy Home Staging, and we'll talk about how to use home staging techniques to create a wow factor to drive buyer traffic, help you sell a home faster and for top dollar. And that'll be Wednesday, September 18th, next month at 1 o'clock. We again thank you for joining us. We know that you're busy. We appreciate you sharing your time with us. To make the most of the time, we encourage you to ask questions and participate utilizing the chat box. I'll monitor the chats and pop the questions over for our speaker. I'd like to introduce Cleve Hill, the managing partner at Georgia Legacy Law Group. Cleve is a neighbor of ours in Alpharetta. We share space in the same building in Alpharetta and have gotten to know each other. And Cleve handles estate probate and estate planning, and thought he'd be an excellent speaker with a great topic for our audience today. He'll talk a little bit about avoiding probate in Georgia, strategies for an efficient estate administration. And at this point, Cleve, I'll go ahead and turn it over to you. I will stop sharing my screen and let you take it from here.
All right. Thank you so much, Doug. And thank you for everybody that has joined us today. We are grateful for the opportunity to be with you. Let me put my PowerPoint up on the screen here. You guys are in the world of real estate, and you may be wondering why in the world would we spend time talking about probate today? But obviously you guys run into this very frequently, as we do. Oftentimes we will get a call from the family real estate agent to let us know that a client has passed away before we will hear from the family. Sometimes you guys are so connected to our clients, and we love that because you can be a connection point for us. You can help get us some background information on the clients if it's folks that we've not worked with before. So building relationships with estate planning and probate attorneys, I think, is a great thing for real estate agents to do, because we're going to come in contact with each other a lot. Historically in Georgia, I've been practicing now 20 years. It's come and gone in a tremendous hurry. But it is still not uncommon for you to walk into an attorney's office here in Georgia to talk about estate planning, and you will hear some clients bring up the issue of trying to avoid probate. Many attorneys would reply to that comment from a client and say, oh, Georgia probate is not that bad. It's easy. You don't need to avoid it. Historically, that has been largely true. Georgia is considered to be one of the easier states to administer a decedent's estate in. Florida, New York, New Jersey, California, and some other states have given probate moniker of being pretty much equivalent of a four-letter word in the public. Georgia has helped soften that a bit. But the problem that we are seeing as Georgia becomes more and more populated, as more people relocate to Georgia, especially in the metropolitan Atlanta area, our probate courts are becoming less efficient. The time in which it is taking for them to process even simple run-of-the-mill probate matters is taking a long time. And I'll share some examples of that today. So we are getting more and more requests from clients, from children, adult children of clients. How can we stay out of this process? So we're going to talk about some examples of that today. Our legislature here in Georgia, as I'm sure you all know, have given us an additional tool in our tool belt in that regard. And I want to talk about that Georgia beneficiary deed that became effective July 1 this year. Talk about some pros and cons with that. Talk about some opportunities. I think our legislature will maybe have to relook at that and tighten it up a little down the road as well. But let's kind of jump in here. And Doug, feel free to interrupt me with questions if you get any in the chat box there. So this is kind of our agenda here today. We're going to look at a brief overview of probate and then go into why it should be avoided and what are some techniques that we can employ to do that. The term probate comes from Latin, as many of our terms do, and the legal profession, as you all know, and much to your chagrin, is still tied to our Latin phrases. So probate means to prove. So when we file a petition to probate a will, we're asking the probate judge to enter the will into the record as being the true last will and testament of the decedent. The judge then reviews the will and the petition to make sure that it's been properly executed. All of the appropriate parties have been given notice of the matter. Of course, we can do probate when there is a will. We can also do the probate process when someone dies without a will. We call that intestacy. So probate is proving the will, or we have this add-on now under the probate heading of getting an administrator appointed when someone dies without a will. So getting that will conclusively proven as being the decedent's, and then getting the person that we call the personal representative. That is an umbrella term to mean the person who is given fiduciary authority to administer the estate. Personal representative means both an executor under a will and an administrator in the context of an intestacy. The probate process also provides a method for putting creditors on notice that a decedent has passed away, gives them information about where to send their claims. Interestingly, in Georgia, and this is different from some other states, creditors have a 90-day period from the running of the 4th week's notice to debtors and creditors to submit their claim to the administrator or executor of the estate. If they don't submit the claim by that 90-day deadline, the claim is not extinguished. Georgia law merely says that they lose their place in priority with other creditors of the same priority. In other words, if there's still assets there to pay the claim, it still has to be paid. Death doesn't extinguish the debt. Some other states, unsecured debt that does not get reported on a claim after the decedent has died goes away. And a lot of people think that's the way it works here in Georgia, but it's not. So this probate process gives us that method of putting creditors on notice. But again, as I said at the beginning of our conversation today, you would normally hear probate's easy in Georgia. Why would you want to avoid it? Well, let's talk about why you might want to have your clients, neighbors, friends, customers look at methods to stay out of the probate court. Georgia law says that estates that go through probate have to remain open at least 6 months. In my experience, they're taking between 12 and 18 months after letters testamentary or letters of administration have been issued. And for larger estates, it's taking longer than that. However, that calculation I just gave you, the 12 or 18 months, is after letters have been issued by the court. Let's talk about the time it's taking them to process the petitions ahead of that. I had a case that we filed in Fulton County Probate Court 9 months ago, 3 siblings, all getting along, perfectly drafted will. It is the textbook picture of clients in probate that you would want to have. Pre-pandemic, 10 years ago, we could have filed this in Fulton County Probate Court with a hand delivery and had letters testamentary issued the same day. This family I'm working with, 9 months for the court to process the petition. So here, these 3 adult children are sitting here with their parents' home that they can't do anything with because the title is in the deceased mother's name. There's bills that need to be paid. We're sitting here for 9 months. So the time for simple processing is really slowing down the administration. I'm picking on Fulton, and you can share with the world that I'm picking on the Fulton County Probate Court. They don't have their act together right now, and it is impacting our practice. It's impacting our colleagues' practices, but we're not only seeing it in Fulton, we're seeing it in other probate courts as well. So we are wanting to find ways to help clients get out of that quagmire to begin with. Another reason that people want to avoid probate is if there is disharmony in the family, if somebody's being cut out, if a child is getting a smaller share than someone else. When we file a probate petition, we are asking the deceased person's next blood relatives to consent, or at least not object, to the probate. Georgia law defines the term heir and beneficiary differently. An heir is a person's next blood relative entitled to notice when probate is filed. A beneficiary is a person named in a will to receive an asset. Now you can see there may be disconnects there. Heirs and beneficiaries are sometimes one and the same, but they don't have to be. Let's say a decedent drafted a will, left everything to his new spouse that was not the mother of his children. If he passes away, that new wife, plus his children from the first marriage, all will be entitled to a copy of the probate petition, a copy of the will, and the children, and I'm picking on the children in this hypothetical, will be given an opportunity to object to the probate. If they don't like the fact that everything's going to stepmother, they can step in at the very beginning and slow the process down. So if there is anticipated litigation or even a threat of it, we want to hear that from our clients so that we can introduce techniques and methods to lower that possibility for a challenge. If the will is not properly drafted or if the person dies without a will, there's going to be additional hoops, procedures, et cetera, to jump through. For example, an additional delay when someone dies without a will. When you file the petition to probate to have an administrator named, an advertisement has to run in the newspaper for 4 weeks. So you will be handed an automatic 30-day delay as soon as you file a petition for letters of administration without a will. So if efficiency and timing is important to clients, and we know it is for all of them, we live in a drive-through world where everybody wants things instantaneously. As estate planning and probate professionals, we want to be helping our clients find ways to make the estate administration as efficient as possible. Now, I have plenty of clients who will come in and say, I'm not going to pay extra to build in the efficiency. I'm leaving this all to them. They can pay for it. And that's a perfectly acceptable response too. But my duty is to share the pros, cons, and what the different options are for the client to consider.
Just Cleve, forgive me, a quick question about
Sure.
probating a will. In the petition to probate, Beyond just notice to all of the heirs, don't all of the heirs have to sign the petition and consent to the petition?
Great question. So there are three options when an heir receives the petition. They can sign it in the presence of a notary public and submit that either to the court or the executor for filing. Second option is to do nothing. So if they are served and they don't respond within the 30-day deadline, it is considered a consent. So the probate will go forward in both of those scenarios. The third option, if they are served, they have 30 days to decide what to do. And if they want to object, they can file what is commonly referred to as a caveat or objection to the entry of the will into probate. So the signatures are not required. They're nice to have ahead of time, but the heir can choose to not sign, or they can choose to object.
Okay, thank you.
Sure. One thing that we, of course, run into with our good friends in your area, real estate, is the clients always want to get the home on the market as quickly as possible. And of course, in the spring and summer months, every telephone call I get on a probate is, how quickly can we get this so we can get the signs stuck in the yard and take advantage of the hot real estate season. Clients need to anticipate that. And that's one of the things I'm sharing with folks is, if your beneficiaries are going to be hot to trot to get things on the market and liquidate things, you might want to consider looking for ways to keep us out of the probate process. It's a process and it takes time. So what's the solution? We're going to talk about 4 of them today. You guys probably, I know all of you have come across most of these. We're going to spend a little time talking about them, and especially the new beneficiary transfer on death deed. Revocable living trust, basically it's an agreement. It's an agreement, oddly, with yourself. You are the creator of the trust. You are typically the initial trustee of the trust. So you are agreeing to take possession of your own assets and administer them according to the terms of your trust. You'll hear them referred to as revocable living trusts, living trusts. Some folks will still use the Latin term inter vivos trust, but all means the same thing. A trust that's created during your lifetime to hold title while you're alive and then pass assets at death. I will have many probate consultations or estate administration consultations where the family will come in and they will set down a leather 3-ring binder on my desk and say, Daddy had a revocable living trust. I guess we can avoid probate. And my next question to them is, well, what did Daddy put in the trust? That is the critical step. If Daddy didn't put his assets in the trust, then we are going to the probate court, assuming there's no survivorship or beneficiary designations on the assets. So the critical step with these, once the trust is established, is to actually have your clients get the assets into the trust. If they are in there, you continue to control them for the remainder of your lifetime while you're in good health. You can name, just like you can in a will, you can name successor trustees who could step in if you became incapacitated. And then the trust acts like a will after you've passed away because it sets forth how the debts and expenses are to be paid and then sets out the roadmap for distribution. But unlike in the context of a will where we have to submit a court action, with the revocable living trust, as soon as the successor trustee has a death certificate, they're off to the races with administering the estate. So while you're alive, it's an extension of you. You control it. You benefit from it. You get to amend it, change it at any time, just like you can with a will. But at death, it creates that private administration. And whoever you put in charge can move pretty much as rapidly as he or she would like. So it's an efficiency play to get us out of that court process. Yes, it provides efficiency from a timing perspective, but it also can help provide that privacy if there's any discord, disharmony in the family. We are not teeing up litigation right out of the gate. So just a little illustration here. You, to begin with, are your own trustee. If you set one of these things up, you want to name at least one successor who could step in upon incapacity or death. You're going to name your beneficiaries. Of course, you, as the creator of the trust, are your own beneficiary during your lifetime. Loved ones, family, friends, charities, etc., are the remainder beneficiaries. The key is getting any of the titled assets into the trust. So getting the home in there, getting commercial properties into the trust. If they've got LLCs and corporations, we want to see if it's appropriate to transfer those ownership interests in the businesses into the trust. Most of the time it will be. And so then we want to go to the financial institutions, have savings, checking, brokerage accounts, either retitled to the trust or have a beneficiary designated on the account to pay into the trust once the owner has passed away. The only asset we don't want to put into the trust are retirement accounts. Our friends and neighbors in Congress have decided, as you know, to put a ton of complicated regulations and laws around retirement plans. And if one is transferred to a trust during your lifetime, it can cause a tremendous amount of negative tax consequences. So leaving those out and just making sure the beneficiary designations are as you want them is the key with those. So how do we accomplish the goal? We get those assets into the trust. Your successor trustee steps in, hands those assets out to the beneficiary as soon as those debts and expenses are paid. So again, it's about efficiency and it's about privacy, and it keeps us out of the probate court. You can have it set up. We use these a lot in our elder law practice here as folks are aging and maybe are not feeling like they can handle the management of their financial affairs anymore. We can get everything consolidated into the living trust, and they can have a successor trustee, whether that's spouse, adult child, what have you, step in and manage those assets during the elderly person's remaining years. And again, the trust is basically what we refer to as a will substitute. It gets us through that administration without the extraneous issues associated with the probate court. So privacy, avoidance is what those will set up for us there. Beneficiary designations are a really confusing area to a lot of people for some reason. There's a lot of confusion around whether or not a person's will or trust, if it is in conflict with a beneficiary designation, which controls? Well, the contract, the beneficiary designation, is what controls. So if I've got a life insurance policy and I name my son Ben on the beneficiary designation, but in my will, I, for whatever reason, state that my life insurance policy is going to go to my daughter, Olivia, well, Ben is going to be the one that receives property. So we always want to underscore to our clients that you need to check these beneficiary designations out because they can become stale. Life changes. The people in our life change. I had a situation a few years ago here in this office. I was doing an initial consult with a couple. They had brought in all their paperwork. I'm looking through it. One of the things I asked them to do is bring any life insurance policies, retirement plans, so I can look at beneficiary designations. I'm going through, I see a life insurance policy statement, and I'm looking at the beneficiary designated on there. The name on the form is not one that I had seen associated with this couple sitting in my office. And so I looked and I said, who is Jane Doe? The husband's face turned as red as a tomato, and he looked at me, and then his wife looked at him, and she said, is that who I think it is? It was his girlfriend from before they got married. He had not gone in and changed the beneficiary designation on his $1.5 million life insurance policy. This couple had been married for 15 years. So I marched myself down the hallway, got onto the website of the life insurance company, downloaded a change of beneficiary form, and I would not let them leave my office without him signing that and us faxing it to the office. So checking these things are extraordinarily important because, and we'll talk about the Kennedy case here in 2009, a case went to the United States Supreme Court. A couple had been married, had gotten divorced, I believe in the 1970s. The husband was an executive at DuPont and had built up quite a hefty retirement account there. After they divorced, guess what he forgot to do? He forgot to take his ex-wife off of the beneficiary designation on that retirement account. So when he passed away, guess who showed up with a claims form at the DuPont HR office? His ex-wife did. His estate sued DuPont and said, you can't pay this to her. They are divorced. There is a divorce decree that says you can't benefit from the death of the other. Well, the United States Supreme Court said, we're sorry. This is a matter of contract law, and that contract says for DuPont to pay that to the ex-spouse. That is the conclusion. However, Justice Kennedy, in a footnote, said, we make no finding today on whether or not the estate of the decedent could sue the ex-spouse for breach of contract if she accepts the money from the DuPont plan. The idea being that the divorce settlement agreement is an agreement, and it says that neither party will benefit upon the death of the other. So, wife, if you claim this, you will be sued for breach of contract. The test case related to that footnote in the Kennedy case was here in Georgia, Alcorn versus Appleton in 2011. And the Georgia court said, yes, the estate can sue the ex-spouse who claimed the funds for breach of contract. Now, of course, the only people who got rich out of this whole thing is the lawyers. We want our clients to make sure that these forms, and everybody views it as a hassle. One more form to fill out, one more thing to do, but it has consequence. And yes, it's a pain when I have my clients pull these things out of their filing cabinet or wherever they put them in their house to look at them, but it is of vital importance that we make sure that these are updated. Yes, it avoids probate, but it can create other problems. So we want to make sure that this is an organized approach to how the clients are leaving their assets.
Cleve, let me jump in with a
Sure.
quick question.
Please.
Talking about trust, how does holding real estate in a trust affect the owner's ability to claim, for example, homestead tax exemption?
Great question, Doug. So the Georgia legislature several years ago updated the real estate code, especially under the homestead exemption category. They specifically went in and said that if a person who resides in the home is a beneficiary of the trust, they are able to get the homestead exemption and the age-based school tax exemption as well. That not only applies to revocable living trusts, it also applies to irrevocable trusts as well. So we do a fair amount of Medicaid asset protection trusts here in our office. And many times the clients are putting in their primary residence. So preserving that homestead and school tax exemption is critical. And so thankfully our legislature has addressed that.
Great, thank you.
Sure.
Question for you on that?
Sure.
Is that no matter what age you are on the school tax?
So it is, I believe it's age 62. It's either 62 or 65.
For it to remain exempt on the school taxes?
Correct. Yeah, it's
Okay.
it's an age-based.
Well, I mean, if one party passes and the other party is left with the homestead, but isn't a certain age on the school tax.
Yeah, then technically they would lose the exemption the following tax year if they themselves had not achieved that age.
62?
I think it's 60. think it's 62, but I would have to look at the code on that. I don't have to deal with exemptions a lot, but I think it's either 62 or 65.
Ironically,
Okay,
for
thank
some
you.
reason, I thought it varied by county.
There, Doug, I think there is some variation. I think, in fact, Cherokee may be 65 and Forsyth may be 62. So you're right, there is some variation in it.
And just to let y'all know too, every county, not only is the age may be different, what type of exemption you get is different. Some counties will totally exempt you. Some counties will only give you a percentage off.
Yeah, that's a great point there too. And I think even some of them have put basically an income cap. If you're over a certain income level, you can only get a percentage of the exemption, or if you're over a certain level, you lose it altogether.
Yeah.
A great point. Back to the beneficiary designations here. Folks will oftentimes name their minor children behind their spouse on these beneficiary designations. In Georgia, if a minor inherits anything in excess of $25,000, it must be tendered into the probate court for a conservatorship to be managed until the child reaches the age of 18. And then you're going to have an 18-year-old walking around with whatever they've inherited. While the idea of the beneficiary designation, of course, is to keep us out of probate, if it goes to a minor, we're back in probate regardless. So having clients think about putting trusts for children, especially minor children, inside their will or inside a living trust, and pointing those beneficiary designations to those trusts are usually the better plan. It keeps us out of that conservatorship, and it allows us to keep the assets protected for the child past the age of 18. So we got a little bit of a reprieve from our legislature a couple of years ago. The $25,000 figure, as recent as 2 years ago, was $15,000. So still a very low threshold, and you could find yourself in a probate court conservatorship with that minor.
I'm
Please,
sorry, I have a question.
Sure.
Is that with or without a will? It doesn't matter?
Doesn't matter if a not even looking in the context of the decedent's estate. If you've got a minor under the age of 18, if they are listed to receive from an estate or a beneficiary designation or a lawsuit settlement, a personal injury settlement, if it's in excess of 25, it's got to go into the conservatorship.
Whether you have a trust set up or not? Or
Well, if you have the trust set up and the trust named as the beneficiary on the designation, then we wouldn't have this issue at all. I have run into plenty of situations where, and I've got one right now, where the client did a will, set up a trust, and the will had intended for everything for his child to run through that trust, but didn't update his beneficiary designation before he died. Everybody in this particular case I'm talking about is on board, so we're going to file an action in the Superior Court to reform the beneficiary designation to point it into the trust. We're getting a little pushback from one of the life insurance companies, but I've told them their job in this whole thing is to cut the check, and if I have a court order that tells them where they're to cut it, that's where they have to cut it. So we're having a little back and forth on that, but there are solutions. It can just be a little more time consuming and costly.
what about when the trust is created upon death?
The trust is created upon death. You still have to have the beneficiary designation pointed to that trust.
Same person. Oh, yeah, right. So then the same person, and that threshold still applies?
No, if you've got a trust and the trust is the beneficiary of, let's say it's a life insurance policy, then the trust is the beneficiary, not the minor. So
No, I mean, it would only be created upon death, though.
that's correct. If it is what we call a testamentary trust,
Right.
that means
right.
it's set up upon death.
Okay, so that would be okay, and it wouldn't go to probate.
If the trust is named as the beneficiary on the designation, then you would avoid the conservatorship. The will would still have to be probated in order for the trust to be brought to life. So in that scenario, if the person died with a will and there's a testamentary trust in the will would have to be probated before the trust could receive the funds.
So do you have to name like the trust and the beneficiary?
Typically, you would list the trustee and the name of the trust as the beneficiary on the designation.
I think that might be it. Okay, thank you.
Sure, yeah,
One
absolutely.
other quick question in that vein is
Sure.
if a retirement account listed a beneficiary who's passed away,
Mhm.
but the trust names the executor as the beneficiary. I'm
Mhm.
assuming that if there was only one beneficiary designation and that beneficiary had previously passed away, then we're no longer working with beneficiary and now we're going to the will terms.
It's going to be governed, Doug, by the plan document. The plan document will have, you'll see some variations on it. Sometimes it will say if the named beneficiary is dead and there is no named contingent, then it will go to the estate, in which case the terms of the will would apply, or if there's no will, the intestacy statutes would apply. So it is, that's just how they will set those things up.
Okay.
All right. Let's, you guys know all about joint tenancy with survivorship. Georgia's got a specific code section on it. There's magic language that needs to appear on the deed, joint tenancy, joint tenants with right of survivorship. There's been a recent Georgia Supreme Court case dealing with a will and whether or not the language in the will created a joint tenancy with survivorship for the beneficiaries or a tenancy in common. And they kept going back to that magic language that appears in the code. And the will in this particular case was not clear. It didn't use those magic language. So the court interpreted that to mean that a tenancy in common had been created. So when we're using joint tenancy with survivorship, we've got to be very, very precise. The downside to doing the joint tenancy with survivorship, two primarily. One, there's no opportunity to do any asset protection. If we had a husband and wife owning a property as tenants in common, if the wife passes away and we've got a marital trust under her will or living trust, her half interest could go into the trust and be protected from the husband's creditors. If the husband got remarried, it would be protected in a divorce action. So when we just have the asset passed directly by operation of law, we lose that opportunity. The other thing that we always look at in a probate consultation is whether or not a petition for years support would be an appropriate method for the surviving spouse. If the home is set up as joint tenants with right of survivorship, some of our county tax commissioners take the position that because title passes the moment the death occurs, that the surviving spouse automatically owns the property. They can't disclaim that automatic passage of title, and therefore there are no property taxes that can be divested from the decedent's estate because title passed. We've got a couple of the metro counties that will let that slide and will allow the spouse to disclaim and still get the divestment of 1 year's worth of property taxes. So again, it's something that we always want to analyze when we're sitting down with clients and strategizing about the best way to achieve their end goal for their beneficiaries. Let's talk here in the last little bit about our new beneficiary deed. For the past decade and a half, it is not uncommon that I would get at least 1 or 2 questions a week about, can I do a ladybird deed? Does Georgia recognize ladybird deeds? Georgia, until July of this year, did not recognize a transfer on death deed. In fact, this one, at least in the fiduciary law practice, surprised us all a bit. There had been a couple of bills dropped last year. The one that ended up getting passed had been a standalone bill and then got tacked on to another. And so a lot of us were surprised when it got through. So now they are available here in Georgia. We've got the code section here on the screen. I think it's a good thing that Georgia has added another tool to our estate planning tool belt here. There are some downsides to this. We'll talk about these as we go through. The legislature has put together a form for the transfer on death deed. It's available in the code book now. The owner would have that deed prepared and name his or her beneficiary or beneficiaries, and then record that deed in the Superior Court records with the other deed records. We've decided here internally, just to help our friends who are title examiners out, we're going to do a cross-reference on all of those deeds to the vesting deed, so that the title examiner can clearly see that when they're going in and doing their searches. The transfer on death deeds got to be witnessed and notarized just like a normal deed. The beneficiaries don't have to sign anything. They don't have to do anything while the owner of the property is alive. It just gets recorded. It's in the record. The owner retains full ownership of the property. They can sell it. They can lease it. They can do anything they want to legally with the property during their lifetime. They are not restricted by the fact that they have named a beneficiary. They can revoke that beneficiary designation at any time. Revocation has been set out in a very clear set of methods here. That can be done on a subsequent deed, which again, I would recommend making sure that there's a cross-reference back to that original vesting deed and to the original beneficiary deed, so that there's no confusion that has been revoked. An affidavit can be signed and recorded. Again, I would want to cross-reference that as well. Or gifting a fee simple ownership to a third party will terminate that beneficiary designation if that's done during the owner's lifetime. And also, they anticipated, what if one of the named beneficiaries passes away prior to the owner of the property? That will terminate any interest that they would have had in the property automatically by virtue of their death. Nothing further has to be done. Getting back to that issue of beneficiary designations versus terms of a will, which controls, the legislature clearly said here that a will cannot trump the transfer on death deed. So even if you've got a conflicting provision in the will, it is not going to revoke that designation. This is the interesting part here that I think we're going to have to pay very close attention to over the next few years as we start to see these deeds being used and come to fruition. I filed my first one last week. The owner of the property, unfortunately, is at death's door. So I think we're going to get to see this procedure, unfortunately, play out pretty quickly here in our office. The beneficiary has to take an affirmative step in order to claim the property, and they've got 9 months to do that. There's a specific procedure, a specific way the affidavit that the beneficiary has got to complete, sign, have notarized, and file in the records. It's got to set forth, of course, that the owner has passed away. For some reason, they've asked for a notation of whether or not the beneficiary was married to the owner of the property at the time of death, and of course, the legal description. Again, best practice, we believe, is to do a cross-reference back to that original TOD deed, again, for our title examiners coming along after the fact. What happens if they don't take this next step of filing that affidavit? And my big question mark around all of this, and again, I'm just talking out loud here, I'm not privy to what the legislators were thinking about this, but why would we require an affirmative procedure with a beneficiary deed, but not with joint tenants with right of survivorship? Yes, it's best practice to file an affidavit of survivorship in the records, but it's not required. Here, I think this is going to lead to a lot of probates. Just like we see those 3-ring binders coming in saying mom and dad had a revocable trust, we avoid probate, right? Well, did you file that affidavit? Did you take that step? I think we're going to run into a lot of that. What I think we're going to see is owners of the property, mom and dad, setting up these transfer on death deeds and either not telling the children that there is an affirmative procedure they must go through after death, or forgetting about it. And then we're going to be back in the probate cycle here. So yes, I think it's a good tool. I think it's a good thing to have available. But I think we're also going to have to ride herd on our clients about making sure that their beneficiaries know what the procedure is after death. The beneficiary is going to have to be able to get a copy of the death certificate. That's one of the requirements. It's got to be attached to that affidavit to receive the property. So I think there is some drawbacks to this, or some potential downsides if the beneficiary isn't organized and can't timely respond to those requirements after the death has occurred. So we're going to see. That's part of the reason I think they call it practice, is we have to let these things kind of play out and see what is going to transpire. But again, I think it's a great thing to have in the tool belt, but I do think there are some issues with it. The other issue for beneficiaries to just be aware of is if there's a mortgage, if there's a lien, anything encumbering that property, when they receive it, that lien, that encumbrance is going to come over to them. It's not extinguished. So that is a brief overview of probate in Georgia and why we might want to avoid it, and some techniques to do so. I don't think any of the techniques are perfect. They take coordination, they take organization, they take being proactive. And if you have clients who can do that, if we have clients that can do that, I think it will produce a great result for their families. I think it will produce a better process when they're working with professionals like you realtors, because everything will be nice packaged up. Yes, there are going to be issues that arise, but as many of those that we can take off the table to make it efficient. We see it as our job to present those options for efficiency to our clients, educate them about it, and then help them put something in place that they're going to be able to carry out. Certainly happy to try to answer any questions that you guys would have, and I certainly do appreciate the opportunity to visit with you today and share a little bit on this topic. Thanks, Doug.
All right, we'll open the floor for questions. Cleve, just one quick question.
Sure.
What are the differences, or why would a person create an irrevocable trust instead of a revocable trust?
Sure. So irrevocable trusts are used primarily in the context of asset protection and in estate tax minimization. Revocable trust, revocable with an R, the assets in the trust are treated as still owned for tax purposes by the creator of the trust. If we have clients who have taxable estates, which currently has to be pretty substantial, $13,610,000 is the estate exemption. So if they are over that, it's very common to set up trusts to start making gift transfers into while the owner of the asset is alive, so that they can take that asset, remove it from their estate, and allow the asset to grow and appreciate inside the irrevocable trust, which is treated as a separate entity. So that's where we see it mostly, asset protection planning and estate tax minimization.
All right. Next question was, if the estate is less than $15,000 and no property, stocks, insurance, is petition for no administration necessary, or will a clause in the will avoid probate? For small estates, that you haven't otherwise taken probate avoidance procedures. What's the workaround in that case?
Yeah, so there's no kind of financial bright line test in Georgia for probate. Some states will have a threshold that if you're below, you can essentially do what some states refer to as a small estate affidavit. And that confuses our clients here in Georgia a lot because these insurance companies that are nationwide will send these letters and say, I need you to provide me with the following. Well, we don't have a small estate affidavit here in Georgia. We do have a financial institution document that if a person dies intestate, a family member can go into the bank and withdraw up to, they just adjusted this. I want to say it's 20 or 25,000 to, if that account is that or below, they can take it out. If there's any outstanding funeral bills, the bank has an obligation to make sure that the funeral home is paid, but otherwise they can release the funds. No administration necessary, can only be used when there is no will and when there is no debt, or where there is debt but the creditor has agreed to the distribution according to how the family has agreed. There is conversation going on in our fiduciary law section of the bar about creating a small estate summary proceeding for probate. That is, in my understanding, very early stages of conversation, but right now we don't have it. If a client dies and they've got an asset in their name with no joint owner with survivorship, no beneficiary designation, if the heir or beneficiary wants that asset, they're going to have to go to probate.
We had a question about setting up special needs trust, and the question was, would they be set up before or after death? And my understanding in most cases, the person creating the trust is creating a trust to take care of someone with special needs and is setting up during both of their lifetimes. I can't think of how you could set up a special needs trust after death, unless it's yours and you want it to go into a trust for special needs after you pass away.
That's correct. So you can actually do it both ways. Sometimes parents or grandparents of a child with special needs will set up during their lifetime essentially a living special needs trust so that family members, friends can all have a consolidated place to send their gifts for the special needs beneficiary. So that can be done that way. And then multiple family members can point their estate plan to that standalone trust if they like and have it funded at death. So that's one option. You can set it up during life and fund it with gifts during life, or it can be a testamentary trust for a special needs beneficiary that we would just direct their inheritance into pursuant to the terms of the will or the revocable living trust.
All right. We had another question about what's the best way to locate a good probate attorney in another state. The particular question was in Kentucky. And I think you had mentioned that there's an association of estate or probate attorneys that meet certain designations. So if you needed a probate attorney in Kentucky, what would be your recommendation on how to find one?
Great question. Where I always start is with the American Council of Trust and Estate, or excuse me, American College of Trust and Estate Council, ACTEC, ACTEC.org. If you go to actec.org, there'll be a place on there that says find a fellow. They refer to their members as fellows. So then you can bear down by zip code and find members of that organization, as closely as you want to get there. But that's always a great source. What I have found with ACTEC is that most of the ACTEC members are focused on high net worth planning. However, they will know the medium and small firms in their local market to refer you to. So that's always a great resource.
And forgive me, I'm going to type it into the chat, so I'll have it available for everybody, and we'll have it in the recording. American College of
Trust and Estate Council.
and Estate Council, and that acronym was ACTEC.
You got it, .org.
.org. Got it.
And they've got a lot of good materials on their website and stuff too, but their network is just fantastic.
Great. Thank you for that tip.
Sure.
So I have a couple questions.
Sure.
What happens when the will of an estate states that you can't contest it?
That's
Or you don't get anything?
it's a great question. So Georgia has been somewhat of a leader in this regard. You can put a provision in your will or trust that says that if a beneficiary files a challenge to the validity of the document or tries to challenge your beneficiary designations, there's a whole host of basically tripwires that you can put in there. And so if they filed the challenge, the no contest clause says that they will be treated as if they are predeceased, and the assets will be distributed as if they died before the testator or trustmaker. What people will do sometimes to make that even stronger is to say, not only will you be treated as predeceased, your descendants will be treated as if they predeceased me as well. Our Georgia Court of Appeals and Georgia Supreme Court have been so forceful in finding these valid that it's almost produced some absurd results in a couple of situations. In fact, the Georgia Court of Appeals upheld one in such an absurd scenario last year that the Supreme Court reversed them and said, look, guys, you took this too far. But I'm saying all this to say Georgia is very clear. The opening line of the Wills and Probate Code says a person may leave their assets to whomever they choose, to the exclusion of their spouse and descendants, and may even leave their assets to a complete stranger. And that's almost a verbatim quote. So to back up that freedom to leave your assets however you want, they allow us to put this no contest clause in. Basically, the will says, here's what I want you to have. And if you decide you want more, then you're putting yourself in jeopardy. I put them in every will and trust I draft. And if a client makes me take it out, I make them sign an acknowledgement that they're the one that forced me to take it out. That's how strongly I believe in them. It is your assets. You worked for them. You decide where they go. And the beneficiaries need to toe the line.
One more question. Is there a statute of limitation to contest a decision of probate court which granted property by way of spousal support to a wife when living heirs were not properly notified?
I would have to, as we were taught in law school, if you don't know the answer to something off the top of your head, you say, I'm going to need to file a supplemental brief on that. I've never had to look at that issue. I do not know.
Generally speaking, the heirs are notified, but I'm not sure what happens if you fail to notify an heir, what the remedy is.
You can definitely set aside a probate if it has been entered by fraudulent means. What we see more frequently is person passes away, family members said, hey, we think Aunt Joan had a will, but nobody can find it. So we're going to file a petition for letters of administration as if she didn't have a will. So they did that. Then a will is found. So then we have to go in, ask the court to set aside the administration, enter the will into probate. Or the opposite situation will be, we'll find a will, probate it. Then somebody says, oh, I found one that's dated later in time. So we have to go back, set aside the old one, open the new one. But fraud should, and in most circumstances will toll the statute and allow somebody to step in and try to set that aside, but I've never had to look at it.
I think that's a good answer, that fraud will toll the statute of limitations, and failing to identify errors that you should know exist would be fraud.
Yep.
But what if you never are in contact with them? How did they contact they would have to be in the will, right?
Not necessarily. I mean, I had a probate case. It's been a year and a half ago. There were 25 heirs, and
Right.
it was all first cousins of this particular gentleman. And yeah, we had to get a private investigator to help us find addresses, and the probate courts will require you to do that. The phrase from the Georgia Supreme Court case that kind of set the standard for this is the personal representative or petitioner must demonstrate some reasonable diligence
Right.
beyond their own personal knowledge to try to locate these heirs. And the courts nowadays interpret that to mean you need to show some effort with getting a professional to try to locate these folks.
So I have a question on that TOD, the 7-1 law or whatever. I'm not real familiar with it, but is it required? Are we all going to be required to do this affidavit so it passes to the spouse even?
Well, only if you're doing a beneficiary deed. If it's a kind of run-of-the-mill joint tenancy with right of survivorship, no, that all stays the same. It's just if
Okay.
one of these new transfer on death deeds is prepared by a property owner and recorded, in order for the named beneficiaries to inherit the property, they have to file that affidavit within the 9-month deadline.
And just in the way of clarification, in a joint tenancy with right of survivorship deed, both owners are on title from the moment they're placed on title as joint tenants. When you use a transfer on death deed, you are not putting them on title. You're creating a future interest that when you die, it transfers on death to them. And in order for them to accept that gift, they have to file the affidavit within 9 months that says, I was named the beneficiary, a transfer on death deed. Here's a death certificate, and I'm filing the affidavit within 9 months of their death.
Mhm.
But the
Okay.
one beneficiary for the property owner is, and we've had situations where well-meaning individuals added people to title and later wished they hadn't. They added
Right.
their girlfriend to title, they didn't get married, and then wanted the girlfriend off title. And they basically had to sue in court for partition to have them removed. Had they added them as transfer on death, well, they're not really an owner until you die, and you can easily remove them from title. So that's a benefit to transfer on death versus joint tenants. The other
Right.
is if you add someone to title and they get judgments and liens against them, they attach to the property because they're a co-owner. And they don't if they don't transfer until death.
Right.
Is it Cleve?
It
I'm
is.
sorry,
Yeah.
Cleve. Do you like charge or do you have an hourly rate or like to review these things? I suspect you're an attorney, right?
I am, yes, ma'am. Yeah, we most of our work we do on a flat fee basis. But if somebody comes in and says, "Hey, I've got an existing plan and I just want to pay you by the hour to review it, give me comments on it," yes, I do that as well. My rate is $4.25 an hour, and then the flat fee side just depends on the relative complexity or simplicity of the plan that's needed after consultation.
Okay, thank you.
Yeah, absolutely.
I want to make sure I got everything in order.
Good thing to do for sure.
Right.
I have a
Cleve,
question.
go ahead.
Do you offer any type of initial consultation to before, to say you would have an appointment to do a will or and trust or a trust?
Like having an initial conversation about whether or not you would want to, put one together. Yeah, we absolutely could do that.
Right, well, under some special circumstances. I've just gotten a lot of different information. My brother has recently done one, but he's in Alabama, and I know there's probably some different laws. And then I have a daughter that has a special need, and pour over wheels, and I'm just my head is just kind of like spinning on
Sure.
what happened.
Well, I'd be happy to chat with you and talk about your options. Even if you end up not working with me, I'd be glad to share ideas with you and get you pointed in the right direction.
Okay, sounds good. Just to, I know it's something that needs to happen, but I'm just not. There's a lot of different things that he said that I haven't necessarily heard in this conversation, but I know that my situation is a little bit different.
Yeah, and that's the thing I tell everybody, or people say to me, "Do you get bored talking about this stuff every day?" I'm like, no, because everybody's situation is different. It keeps things
And
interesting.
yes, thank you.
Sure.
Hi, this is Shanita. I actually put in that question because it's a real life scenario, and it kind of, I guess, kind of falls between both of you attorneys. And I'm curious because this is the question around the spousal support, because that known error in my mind creates a cloud on the title. So if that individual wanted to put that property as an asset in a trust or do anything with that property with this error lingering out there that could contest that property, I'm just curious, like how the courts would handle something like that.
Well, again, I'd need to kind of get into all the facts and details, but I think one of the if locating that unknown error is part of the problem, Georgia still allows for notice by publication in the newspaper. So there ought to be some way to put that error on notice via publication, even if they can't be located, to kind of close that issue so that we don't have a title cloud out there. And I guess the other avenue they could potentially go to would be a quiet title action, just to kind of get something on the record that, hey, here's all the steps we've taken. And the judge is satisfied that we've taken all the reasonable diligence that we need to take. It wouldn't be an inexpensive process, but I think that may be the way they'd have to look at it.
Okay. And I'll speak with you offline because it may be something I might need to hire you for, because this is an actual known error situation. And Attorney Doug mentioned about fraudulent. This is definitely a fraudulent situation where someone omitted a child out of when they named children in spousal support as heirs, and they knew the child, if that makes sense.
Okay. Well, now I'm going to be curious after we get offline. I'm going to go pull my treatise out and see if I can pinpoint an answer to that.
Yes, but we can talk offline. I appreciate it. Thank you.
Sure.
Sure.
Do the courts generally hold up the law or the will?
The law favors finding the will to be valid. So the court is looking for ways to find it to be valid. So because we put such power and right behind being able to distribute our assets, the court wants to honor that paramount right for us to be able to distribute our property however we want. So, it's going to be favored to find it to be valid. They're going to do everything they can to do that. But obviously, there's going to be ones that come through that are going to be rife with undue influence, improper, execution of the document. So,
What if they sue the beneficiary?
if who sues the beneficiary?
I'm sorry?
I didn't understand the question.
What if a heir is excluded from the will
Mhm.
and sues the beneficiary?
if they sue the beneficiary that received an inheritance that they thought should
Right.
belong to them,
Right.
I've never seen that happen. I would think there would be some standing issues, legal standing to be able to bring a claim. What right does an omitted beneficiary have to sue? You know, it's kind of illusory there, in my opinion. But
Okay.
people sue over crazy
As
things.
long as the will is valid, it should be fine.
That's
Right.
And I think their remedy is going to be against the personal representative and the estate, not the beneficiary.
Yeah, well, if even there, you know, I think there'd have to be some allegation that the executor or personal representative had done something inappropriate in that regard. But yeah.
Well, if there are no other questions, I just want to take a moment and thank Cleve for being our guest speaker today on the Business Builder Speaker Series. I knew that it would be a good topic and relevant for those in real estate, and I want to thank Cleve for spending his time with us this afternoon. Do check our website at shafritz-dean.com under the Resources tab, and you'll find a list of all of our Business Builder videos. This one, give us a week or two. We edit the video, clean it up a little bit, add the credits and the theme music and so forth. But it'll be posted up on our web within a week or two. So you'll be able to go back and review it and share it with others that would benefit from the information. And in closing, I just want to wish you all well in your real estate. And I put Cleve's contact information in the chat window, and we'll include it in the closing credits in the video so that you'll know how to reach either Cleve or I if there's something that we can help you with. But thank you, and thank you for joining us, and have a great day. And we'll look forward to seeing you again soon.